On October 28th, Melissa, a Category 5 hurricane, turned her wrath upon our homeland, Jamaica. In the aftermath, thousands of homes were destroyed, lives, pets, and livestock were lost, and dreams and hopes dashed. Resilient as we Jamaicans are known to be, our brothers and sisters on the island need our help now. To this end, the One Jamaica Legal Defense Foundation, OJLDF, has launched its official fundraiser. Please donate generously at OJLDF.net. We are depending on each and every one of you to get the most needed supplies to our people at home. Go to OJLDF.net. That's OJLDF.net and hit the donate button today. Thank you.
For the people every day, defending your rights. I saw him stay. We'll fight for the people every day. Risk him life for the people every day. Get criticized for the people every day. Defending your rights. I saw him stay. Say from him slip up all eyes on him. I defend the people, them set spice on him. Evil politicians spread lies on him. But we know the bugger them not wise like him. Ties on him. Them know said that the people rely upon him. You know said them bring out them cries through him. That's why all the people them respect him. Just like Selassie and Marcus Garvey, rock you all the order of the Trinity. A real strong soldier in a army. No simpleton can disarm you. We'll fight for the people every day. Risk him life for the people every day. Criticized for the people every day, defending your rights. I saw him stay. We'll fight for the people every day. Risk him life for the people every day. Get criticized for the people every day, defending your rights. I saw him stay. How long them a gonna know say that them fire can't cool? How long them a gonna take our people for fool? Nah build no houses, them nah build no school. Think them up the handle, but the most I rule. Them better stop criticizing. Cause what them a do now phase him. You know the man no lazy. All them a talk, them are the one right crazy. We'll fight for the people every day. Risk him life for the people every day. Get criticized for the people every day. Defending your rights. I saw him stay. We'll fight for the people every day. Risk him life for the people every day. Criticized for the people every day, defending your rights. I saw him stay. Say from him slip up all eyes on him. I defend the people, them set spice on him. Even politicians spread lies on him. But we know the bugger them not wise like him. Back up, them not no ties on him. Them know said that the people rely upon him. You know said them bring out them cries through him. That's why all the people them respect him. Just like Selassie and Marcus Garvey, the man hold the order of the Trinity. A real strong soldier in a army. No simpleton can disarm you. Them fight for the people every day. Risk them life for the people every day. Get criticized for the people every day. Defending your rights. I saw him stay. Them fight for the people every day. Risk them life for the people every day. Get criticized for the people every day. Defending your rights. I saw him stay. Them fight for the people every day. Risk him life for the people every day. Get criticized for the people every day. Defending your rights.
Yes. Good evening, good night, good morning, good afternoon, wherever you are in the world. As long as you're tuned in to this special broadcast, greetings. Well, folks, tonight is a very, very special night, very special program. Normally, we're not on a Monday night, except when we're visiting with our dear friend, Mr. Jeffrey Tavares. But as most of you know, we've been anticipating this decision from the Supreme Court concerning the actions of the constituted authority concerning the election on September 3rd in West Central St. Andrew. And who's the MP over there? None other than the Prime Minister, Prime Minister Andrew Holness. So this is something that we planned because we decided that win, lose, or draw, we were going to do something about this decision. Talk about it to educate people. And, you know, as we said all along, we're training people to be, not experts, but to understand civics. I'm just looking at some of the comments in the chat. People in the chat, big up on yourself, each and every one of you. I wish I could do like we do on a Wednesday and start doing it, but it's going to take up too much time, and we have a lot to cover, even though it's basically one subject. Now, let me start out by saying that whatever the decision was going to be, I want you to understand this, people. You have to respect the decision of the judiciary. You may not agree with it, but you have to respect it. And that's the nature of our system, that there's something called rule of law, respect for law, and that's it. So I have read the judge's opinion. I respect it. However, I respectfully disagree. And that's the nature, again, it's the nature of our system. So if you disagree, there are avenues you seek for remedy. You can appeal. Or you can just decide that you're not going to do anything. But you remember, I was asking all of you to put aside $100 US. Or whatever you can afford. $20, $200, $2,000. Anticipating an adverse judgment like the one today. I believe, based on my reading, that the judge made some serious errors. And the only way to correct this is to file an appeal. And so this coming Saturday, we're going to provide you with the information where you can send your donation to fight this appeal. And let me be absolutely clear. The money is not going to the candidate. It's not going to a political party. It's going to the attorney who will be representing this principle in front of the Court of Appeal. What principle? The principle of good governance. The principle of the rule of law. The principle of the sanctity of the election process. That's what we're fighting for. Because we believe that the constituted authority overstepped its boundary. So that's just a prelude. Let me just say that the program tonight, in order to understand this decision, we have to go back. We have to go way back. And we have to come to terms with the system that we operate under. And then we're going to look at some decisions. And I promise you this. When we go back and we look at the 1998, 27 years ago, we look at that decision, you will understand when we fast forward to 2025 and we looked at two laws. We're only going to look at two laws. when we walk through those laws, you will understand that the judge made a mistake. Well, the judge erred. She made an error. But we still have to respect the decision. We don't have to accept it, but we have to respect it. Just like how you would respect a decision in your favor. You have to respect a decision that's not in your favor, or an adverse decision. Have to. All right. The first thing we want to do is we want to look at the system of government we have in Jamaica. That's where we need to start. And then we slowly work our way into the decision. I should say decisions, because there are two of them. Actually, three. There's one from 1998 that we're going to look at, and we have a couple we're going to look at for 2025. Kezia Couture says, Ratty, the judge say him take too long for file. It is that true or not true? Stay tuned. Here we go, people. OT, I'm going to need you to, our producer, John, I'm going to need you to kind of expand this. I'll put it on the screen, and please expand it so that everybody can see it, because I can't do it from where I am. Here we go. Can everybody see this? See the screen? Yes? No? Okay. All right, folks, listen. Here's what we're going to do. Here's what we're going to do. Run. Tell your family, friends, neighbors, whomever. Tell them to tune in, because guess what? We have Mr. Hugh Wildman with us in the studio, live and direct. And this is like kind of a surprise. Oh, you can't do it? Okay. All right. It's kind of a surprise, but I have I had my program all laid out with everything. But since Mr. Wildman is here, I think I should just bring him on and we'll go from there. All right, let me move this. Mr. Wildman, are you there, sir? Oh, he's gone. He was just there. He was just there. So, okay, here he is. All right, Mr. Wildman, are you there, sir? We can't see you. We can't hear you.
Yeah, sir.
Yes, we can hear you, but we can't see you. And we have a lot of people. Oh, your lovely assistant is there.
What time you want me to come on, Ratty? What time you want me to come on?
You want to? Is 9 o'clock good for you? Is half hour from now good for you?
Okay, fine. All right, yeah.
Okay,
Yeah.
good. Fair. All right. All right, folks. All right, let me put this back. All right. I want him to come on, but I want to set the scene. Because some of well, some people are asking who is Hugh Wildman, and some people don't understand the history behind this case. It just didn't start September 3rd. There are connections going all the way back to 1997, 1998. All right. Government of Jamaica, an overview, right? This, we can't get it any bigger than this? Nope. OT, June, can't get it any bigger than this? Yes, no? All right. At the top of this, you see monarch. That's King Charles the King of Jamaica. And then below him, folks, tell me if you can see. Tell me if you can see. Tell me if you, all right, control this. This is not going to work for me. I don't want to mess with it because the last time I did this, the entire screen went blank. So just tell me if you can read what's on the screen. Yes? Okay. Leonie says yes. All right. See, monarch, that's King Charles III, the King of Jamaica. That's an official title, King of Jamaica. Then he's represented by the Governor General. And then right below the Governor General, you see the Services Commission and the Privy Council. The Privy Council is not the Privy Council in England. That's the Privy Council. That's an advisory body to the Governor General. And then you have the Services Commission, you know, the Police Services Commission, Public Services Commission there. But if you go straight down from the Governor General, straight down, you see three large boxes and a different color. On my screen, over here, it's showing yellow. On the screen that you're looking at, it shows a different color. But it says legislature, executive, and judiciary. This is all civics, people. The legislature, they make the laws. That's Parliament. And you see it right there, Senate, House of Representatives. What that means is that the opposition party is part of government. Technically, they're part of government because they're part of both the Senate. They have representatives in the Senate. They have representatives in the House of Representatives. And guess what? They vote. And then below that, you see the Auditor General. In the middle, you see the executive. That's the Prime Minister's office. They're responsible for driving policies and implementing the laws. So you have Prime Minister, you have the Cabinet, ministries below. And to the far right, you have the judiciary. Court of Appeal, Supreme Court, special courts, resident magistrate courts, etc. And then next to RM courts, you see Attorney General. That's under executive. The attorney. Oh, and let me make something abundantly clear. The case that was decided today, it wasn't Paul Buchanan versus Andrew Holness. Paul Buchanan was not suing Andrew Holness. He was suing the constituted authority for the decision they made. So Prime Minister Andrew Holness is not a part of this lawsuit in terms of being a party to it. He's affected one way or the other, but he's not a party to it, not a named party to it. So we need to understand that. So we had a decision today. That decision can be appealed to the Court of Appeal. Let's just be clear about that. So this is government. Now, the reason why I show you this is because, see, the legislature, there are three branches of government in Jamaica, three branches, three groups that run the country. Legislature, they make the laws. Executive, they drive policies. And judiciary, they interpret the laws. They interpret the laws. So they try to get into the head. Whenever there is a law that's a problem, they will then look at it, examine it, and try to interpret it. In other words, they're trying to get into the heads of the legislatures. They're trying to get into the head of the people and say, okay, what did they mean when they passed this law? Well, one way to find out is to go to the Hansard. And most of you here, you know what the Hansard is. The Hansard is the transcript of the discussion regarding the debate of a bill. When they're debating a bill, the Hansard is there. So you can go back and you can see who said what before the bill was passed. So you can get a sense of where they were going. And that's why I can tell you that the Integrity Commission Act is flawed, because I went to the Hansard and I saw where they were actually discussing loopholes. And those loopholes that they were discussing, you can find them in the law today. They didn't take them out. They left them there. So if you really want to know what these legislatures, what these parliamentarians were thinking when they passed this law, you need to go to the Hansard. But you need to go to the Hansard in its totality. In this case, you'll see where the judge went to the Hansard and she quoted Peter Phillips, but we don't know what she left out because she didn't quote the entire thing. She went to just one little section, and we know how that can be. So there you have it. The legislature, executive, judiciary. Remember that, my people. If you forget everything else about this chart, if you forget that the Attorney General is actually representing the government, and when I say the government, the constituted authority. If you remember that, if you forget that, don't forget that Jamaica has 3 branches that form the government: legislature, executive, judiciary. And there is supposed to be a separation of powers. But think about this. Who's in charge of the legislature? Who's the speaker? Speaker Juliet Holness. Who's in charge of the executive? The prime minister. So you have 2 branches of government living, eating, sleeping under the same roof. The question is that separation of power? Is that what was contemplated by the people who put together this system? That you can have a husband running one branch of government and you have a wife running another branch of government. What's next? We're going to have a son running the judiciary and then the family control the whole thing? I don't know. But the legislature, just keep in mind that the legislature, they're talking about parliament, and the speaker is there. She controls the mandate. She controls the schedule. She controls a very powerful position. And she's there. Legally, there's nothing wrong with it. Legally. Morally, it's bankrupt. It's bankrupt. So just keep that in mind. So you have 2 parties living under the same roof, controlling 2 branches of government, and the third is controlled by the judiciary. And so you would start to think, and I can understand, I don't have any evidence of it, but I can understand when people say it is a corrupt practice, a corrupt system. I can understand that when they say it. I don't have the evidence, but I can understand why people would say that. Now we're going to get into the meat of the matter. All right. So we're finished with the government of Jamaica overview. And what we need to do now is, let me show you. We did this already, but I'll show you again. Here we go. All right. Let me remove this. This is not the one I'm looking for. Hold on. Remember this, people? Remember this? That on election day, the prime minister was down by a few hundred votes, and then there was a blackout, and then when things came back, when the reception came back, he was up by more than 2,000. Remember this? This is what this whole argument is about. It's about who won that election and did they win fair and square. Mr. Paul Buchanan is saying, no. it wasn't an election that you that you can reasonably call fair and square. It wasn't. That's his contention. And he take it up with the constituted authority, and therein lies a problem. Now, what I'm going to do now is I'm going to show you a couple of laws. And here's why it's important. You can't move forward unless you see the guidelines to say, okay, this is left, this is right, this is straight, this is back. You can't move forward unless you know what you're dealing with, right? Once we're done with that, then we're going to go to how the rules were applied in a previous case. So the first one is the Election Petitions Act. And I'll break this down for you. Now, this law was established, I think we have it right here. Here it is right there. There you go. This law was established on the 17th of April, 1885. 1885. And it's been amended several times. The amendments, oh, well, the amendments are right there. The amendments are right there. The last time it was amended was in 2002, right? My screen has gone. OT, can you refresh, please? Hold on, folks. My screen just went blank, so I can't see anything. So let me call.
Now, yeah, our people need to see the light. Turn it up right. We will fight for the people every day. Risk him life for the people every day. Get criticized for the people every day. Defending your rights, I saw him stay. We'll fight for the people every day. Risk him life for the people every day. Get criticized for the people every day. Defending your rights, I saw him stay. Say from him step up all eyes on him. I defend the people, them said spice on him. Evil politicians spread lies on him. But we know the bugger them not wise like him. Back up, then I not ties on him. Them know said that the people rely on him. You know said them bring out them cries through him. That's why all the people them respect him. Just like Selassie and
Mic check.
You all the order of the
All right,
Trinity.
okay.
A real strong soldier in a army. No simpleton can this.
All right, my people. A little delay here. We don't know what's going on, but how my sound? And you can't hear me? Mic check. Sound is back. Good. All right. Here we go. Remember I was talking about this law, the Election Petitions Act, and that it was enacted 17th of April, 1885, long time ago. And then it was last amended in 2002. Just going to show you a couple of things, and you have to keep these things in mind when we start analyzing the court's decision. Now, here's the first thing. Election petition. This one right here. This one. Right? Keep that in mind. Petition or election petition shall mean a petition complaining of an undue return or undue election, of a member of the House of Representatives or a councillor of a parish council or the Kingston and St. Andrew Corporation presented to whom? To the Supreme Court under the provisions of this act. I need you to keep that in mind. An election petition. And where is it filed? It's filed with the Supreme Court. Look at 3. A petition may be presented to the Supreme Court by any one or more of the following persons. And it starts telling you in relation to that. Here it says, the following provisions shall apply to the presentation of an election process. And the petition shall be, where you see the big red dot, the petition shall be presented to the registrar of the Supreme Court within 21 days after the return has been made of the member to whose election the petition relates. 21 days after the election. And then in some instances, it's if you want to prove corruption with the election process, then it's 28 days, right? And then it says right here, you see that red dot, at the time of the presentation of the petition or within 3 days afterwards, at the time you file this or 3 days after that, you have to put up some money, some security. Because you have to have some skin in the game. They don't want you to just willy-nilly just file these things. So they said, no, you have to put up security for the payment of the costs and charges and expenses that may become payable. So you have to put up some money. Keep this in mind. Remember, 1, an election petition must be filed in the Supreme Court. If you notice, it doesn't say anything about constituted authority. It says an election petition, you have to file it in the Supreme Court. And you have to file it within 21 days after the return concerning the election. And at the time that you're filing it, you have to put up some security. You have to put up a deposit. Remember those 3 things. Because what we're going to show you is that Paul Buchanan did not file an election petition. The judge made a big to-do about it. And she's like, yeah, with the petition, you have to have this date, and you didn't file it within this time. He didn't file an election petition. And I'm going to show you. Now, let's go down. And here's the security that you have to pay. And when you file that petition, we're going through the election petition now. And remember what I said. Remember what I said. Paul Buchanan did not file an election petition with the Supreme Court. Remember that. And it says here that if you file an election petition, here are the things that you have to do. You must state the particulars. You must state with a statement of the relief, the act that you're complaining about, and within 10 days, blah, blah. It gives you all of these things. Reason why I'm not going through all of this with you is because he did not file an election petition. He did not. So, but I'm just letting you know that there is something called an election petition. Now, let me go down further and show you something else. That's why it pays to read, people, and have an understanding. Now, here we're now talking about the election court, right? And this election court, remember, no, it's not talking about the Supreme Court where you file the election petition. This is a different court. It comes under the Supreme Court, but it's a different court. This court was created later. This, and I'll show you. So it says the election shall have the power to hear applications, not petitions. Where? By way of originating motion from where? Not from you, but from the constituted authority. The two different things we're talking about. One, you file it. One of them you file, and it's filed in the Supreme Court. And then you have a certain amount of days, and then you have to pay a security deposit. Second one is they're talking about the election court. I said the election court will hear applications from not from the Supreme Court or from the individual, but from the constituted authority. And I'm going to show you where the constituted authority, where that body falls in the scheme of things. And it says to declare in relation to such applications, you have to tell them that you do it if you think that the poll is void or that or it's not void. And here's where it says here, the election court, again, the election court, not the Supreme Court, may make declarations in respect to, and it gives you a list of things. The election court. One of them is it has to, once it meets and an oral argument is over, they have 2 days to deliver a decision. The Supreme Court could take months. People, I hope you understand what I'm saying. It's two different courts, the Supreme Court and the election court. The election court, the rule says, once you finish with your oral argument, 2 days maximum, and they have to give a decision. Supreme Court could take months. And the whole process with the election court says here, it shall terminate within 6 months of the date of the taking of a poll to determine all matters brought before the court. So, for example, the election court came into effect, I think, on around in September. And that court will stand for 6 months until next March. Until next March. Now, here's what it says. It says the constituted, remember, no, it's not you bringing the action, it's the constituted authority, because you go to them and they now look at your petition, they look at your affidavits, and then they go to the election court. And here are the bases for them going to the election court. One is where the total number of votes cast in a constituency or electoral divisions exceeds the number of electors on the official list for that constituency or electoral division. What that means is that when they look, they say 500 people voting. But when they look at the list, the registration list, the people who are supposed to vote, they say 300. Obviously, something is wrong there. If you only have 300 registered voters and you see 500 people voting, you know something is wrong. So they said that's one of the grounds. Another ground is where the ballot boxes have been stolen or destroyed or been tampered with. And the number of electors on the list of electors for the polling station is more than the difference in the number of votes cast for the candidate declared the winner and the candidate who's not declared the winner. All that saying that if there is any shenanigans with the ballot boxes, stolen, destroyed, tampered with, problem. Here's a third one, that the presiding officer, the person who's in the polling station, that somebody, put a gun to the person's head and say, sign the ballots, where you intimidate the person, put the person under duress, and the person have to sign off on the ballots. 4, that there are people voting who should not be voting, or people voted who shouldn't vote. And when I say a bona fide electors, when I see that thing, I'm thinking, what about somebody who votes twice? You can only vote once, one man, one vote, same man, same vote. So that person, to me, wouldn't be a bona fide elector for the second vote. For the first vote, yes, but that's a problem. And number 5 is that where there is violence, or, and this is key, any irregularity during election day, any irregularity during election day in one or more polling stations or polling divisions or in any electoral division or constituency. And here's the key. So you should read 5E, you should read it as any irregularity which would lead to a substantial distortion or subversion of the process of free and fair election. What does that mean? It means you only need one. Any irregularity, one or more, that would distort or subvert the process of free and fair election. So, for example, if the ballot boxes are missing, yes. If they're supposed to go a certain direction from the polling station to the counting station, and they go a different route, and then people can't find them, and then they show up later on, you cannot call that free and fair election. If somebody threatens the presiding officer inside the station, can't consider free and fair election. If the presiding officer votes for people, cannot be. You don't need all of those. You need just one. Just one. Those are the bases on which the constituted authority or the election court will take into consideration. There it is right there. The constituted authority may apply to the election court for the voiding of the taking of a poll on one or more. See it right there, 37, on one or more of the following grounds. So 1, 2, 3, as long as you have one, you're fine. All right. Let me see what else is here. And here it is, where the constituted authority, the people that you go to file for you, make an application to the election court. The application shall be made within 28 days of the taking of the poll. And much has been made about the fact that much has been made about whether or not the filings took place in a timely manner, because they're saying it's too late, they filed too late. I'm going to show you that they didn't file too late. And then the hearing shall commence within 60 days after the application is filed. And then remember, you only have once the arguments are heard, 2 days, and then they have to give that is the election court, not the Supreme Court, election court, they will have to render a decision. And then they say the election court may extend the period for the filing of an application where they believe that based on the circumstances, the period ought to be extended, and they can do so for 3 days after the period specified. All right? We're clear on that. I hope we're clear on that, because now, remember I told you there are 2 laws involved. The Election Petition Act, and the other one is the Representation of the People Act. This one you're looking at, the Election Petitions Act. Remember what I told you, that this law came into effect in 1885. Not 1985, 1885. And was amended throughout the years. And the last amendment was in 2002. Here is the Representation of the People Act. See? It came into effect 1944, not 1885, 1944. And it was amended many times over. And the last amendment was right here, 2016. What does it say about elections? Let's run through it. Just a few, I'm just going to show you a few portions, and I think I've highlighted them because we don't want to spend too much time on this. Actually, we want to spend some time on this because this is where the rubber meets the road. 52A, hold on. Okay, oops. Okay, 52A. Bear with me. We're getting to 52A. Actually, 44B. All right, here we go. 44B. Okay. 44B talks about, again, it talks about all the reasons why you may stop taking, you may stop the election. If they don't open on time, earthquake, flood, fire, so on and so forth. Let's get to 52, because 52 is where the problem is. Or that 52 is going to create the problem. All right. 52A1. Here we go. Here we go, people. Remember that the Election Petitions Act says that you file it with the Supreme Court. You have a certain amount of time. You state the reasons, and then you have to put up a security deposit. It mentions nothing about going to the constituted authority, except in the last part of it, it says you go to the election court. And how do you get to the election court? You go through the constituted authority. And this coming Saturday, we're going to put up a chart so that you can see it, because some people are visual. I understand that. And we're going to put up a chart so that you can see it for yourselves. But here's what it says. It says, when after the taking of a poll, the constituted authority or a candidate is of the opinion that during the taking of the poll, circumstances existed which could constitute grounds as specified in section 37. We just looked at 37. Remember the 5 reasons I gave you. It says the constituted authority may on its own motion or at the request of the candidate make an application under that section to the election court. What does that mean? Means that if I'm complaining about, if I lost the election and I'm complaining, I can't file it on my own. I can't go to the election court on my own. I have to take it to the constituted authority. And I have to take it with what? Affidavits. They don't require witness testimony, live people there testifying what they saw, what they did. They don't require that. Videos, they don't require that. Audio, they don't require any other evidence. No, the only thing they need is just a piece of paper saying, I swear that on such and such a day, this is what I saw. That's all you need. Look at number 2. The constituted authority may, before making an application under subsection 1 on its own motion, request a returning officer to furnish it with reports as are necessary to determine that an application ought to be made, and the returning officer shall furnish the constituted authority with such reports. What does that mean? It means that the constituted authority, this body, right, this organization, this entity, that, and it's the only, you can go the other route to the Supreme Court. But why would you want to do that? Because it's going to take a long time. That's why they put this in here, to short circuit the thing, to say, look, you don't have to go to the Supreme Court and spend a whole lot of time waiting on, because remember, this thing has to be wrapped up within 6 months. So they say you can go here, but you don't go to the court directly. You have to go to the constituted authority, and then you give them your affidavits, and then they will then look at the affidavits, and then they will do the application for you with the election court, or they can do it on their own. If they get wind that something is going wrong or something went wrong, they on their own can say to the presiding officer or the returning officer, they can request someone to say, bring us evidence regarding this. We're hearing things, we're not sure. Bring us the evidence. That's 1. 2, which is number 3, it says a candidate who is desirous of having the constituted authority make an application on his behalf to the election court shall, within 14 days of the taking of the poll, 14 days after September 3rd, make such request and shall furnish the constituted authority with such evidence on which he relies, which shall be by affidavit. Do not forget that. The only thing they need you to do is just provide affidavit with somebody saying, I swear that this is what happened, this is what I saw. And you do that, why? So that the constituted authority may determine whether an application ought to be made. No. What does that mean? What this means is simply this. The constituted authority is supposed to look at the four corners of that document to see if any of the five things that we just mentioned in the Election Petitions Act matches your complaint. That's all. They're not supposed to start looking at the weight of the evidence and start saying, well, this person said that and that. No. As long as you make out a complaint that satisfies the five things we talked about. If you didn't mention any of the five things, then they can, they have the discretion to say, we're not going to send this on. We're not going to send this on because you haven't made out your claim. How do you make out your claim? You do one of the five things. You mention one of the five things. At least one. In an affidavit. And then the election court has 14 days to send it. Sorry, the constituted authority has 14 days to send it off to the election court. That's the time period. Let me 52A3, 1 second. Okay, so that's it. Here are the five things again. Let me just go back. Here are the five things. Here are the five things. One, that more people voted than registered. Two, ballot boxes stolen, destroyed, tampered with. Three, the presiding officer was threatened to sign off on the thing. Four, people voting who shouldn't vote. And five, any irregularity that would lead to the belief that this election was not free and this election was not fair. That's it. That's it. Now, let me show you how this was applied. Let me show you. Let me move this. And then let me just show you this chart. Let me just simplify it. Here it is. You have the election, and you're the losing candidate. You're on the left. You can go to the constituted authority, or the constituted authority could do what's on the right on its own volition, meaning that they're hearing things and they're saying, we're going to do this on our own. That's how you get to the constituted authority. But you as a losing candidate cannot go to the court. You cannot go to the court. The constituted authority then will go to the election court for you. That's how it works. Now let me show you how it was applied. 1 second. Okay. Now, people, get ready for some shocks. Some of you have seen this before, but still shocking, even to me. Here we go. If you look here, you see that this says in the matter of the Representation of the People Act and the matter of the Elections Petition Act and in the matter of the application by the constituted blah, 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 blah. This case was argued March 2nd, 3rd, 4th, 5th, because remember now, this is the election court. They had to listen. When you get to the court, that's when you test the evidence. Before that, you just write down the evidence. You just write and say, yeah, a person will will attest to telling the truth concerning certain events. They just write it on paper. Say, I swear that this is what I saw happened. And the constituted authority is supposed to look at that to see that it's one of the five, at least one of the five. But then when it gets to court, that's when you start testing what was written on paper. They bring people in and they start saying, you said it, and they start cross-examining them and all, just to make sure. That's when you can do the videotape and the audio tape and the live witness testimony, and people get cross-examined against what they wrote. That's why you see when it says heard March 2nd, 3rd, 4th, 5th, they're doing all of that. The court is doing all of that. This case was argued in 1998. 1998. And this is the case of Mr. Warren Blake arguing that Mr. Andrew Holness did not win the election fair and square. 1998. The election was in December 1997. Oh, Mr. Wildman is here. All right. You know what, people? If there's one person who can do justice to this topic, it is Mr. Wildman. And I'm so happy he's here. We're going to invite him. Let me remove this thing off. Mr. Wildman. You're muted, Mr. Wildman.
Good night. Good night.
Mr. Wildman, welcome, 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 welcome.
Thanks.
I see you have your most able assistant there. Hi, assistant. Listen, Mr. Wildman.
Yes.
I'm doing well. Thanks for asking. And you?
We are doing excellent.
Good. Outstanding. Outstanding. Mr. Wildman.
Yes, sir. What's happening?
Sir. And I think I just mentioned to my lovely audience that if there's one person who can do justice to this topic, it's you. And what I did, just to give you, just to, you know, to get you up to speed, what I did, I went back and I showed them a chart and explained the system of governance we have in Jamaica. You know, the legislature, the executive, and the judiciary, and explain to them that the judiciary is responsible for, you know, the operation of the courts, and legally, there's nothing wrong with having two people living under the same roof that control two branches of government, but morally, we believe that there's something wrong with that, and that happens to be the case of the Prime Minister and his wife. But that's an aside. Then we got into the Election Petitions Act. And then we just finished up with the Representation of the People Act, where I was trying to explain to my audience that the Elections Petitions Act deals with election petitions filed with the Supreme Court. Has nothing to do with the constituted authority, has nothing to do with the election court. Then we went to section, I think it was section 37 of it, where they started talking about how you can bring certain actions. There are basically five grounds. Then we moved on to the Representation of the People Act, and we started talking about that. So what I'd like you to do, sir, is please take the platform and explain to us the difference between the Election Petitions Act and the Representation of the People Act regarding the complaint about how an election was conducted.
Well, the Election Petition Act is the method that's the legislation that tells you how you approach the court to challenge the outcome of an election. Whereas the Representation of the People's Act tells you what are the requirements of free and fair election. So you have to observe those requirements in order for the election to be considered to be free and fair. So the two acts work in harmony. So you have the constituted authority was set up by virtue of an amendment to the Representation of the People's Act, which provides another method by which you can challenge the outcome of an election. Previously, it was by way of an election petition and the Election Petition Act.
Correct.
So the legislature had another layer, so to speak, which is quicker, faster, for you to challenge the outcome of an election where you think that the election was conducted in an unfair manner.
Mm-hmm.
So that's the relationship between both legislation.
Right. I was just showing the 1998 election court's decision in the matter concerning Mr. Holness. And I just want to put up this one section here and see where it says right here, folks. It says right here, because they were complaining about irregularities. That's number 5 of the 5 things that I talked to you about. Irregularities concerning how the election was conducted that made it made it not to be fair and free. Now look at what the court says here. It says the motion to void an election clearly is not an election petition.
Exactly.
It says the voiding of an election is a new and
that's correct. And that's the point I've been making all along.
It's right there.
It's there.
It only the constituted authority that can move the court to void the taking of.
That's correct. That's correct.
So, Mr. Wildman, tell us what are your grosses? What are your concerns about the decision? Because people have been saying to me, oh, you know, the complaint wasn't filed in a timely fashion. It was late. The judge said it was late. And I'm trying to please address that, sir.
It's absolute nonsense. Before I got into the case, Mr. Buchanan and his team compiled the evidence after the election and place it before the Constituted Authority within the time, because they have 14 days after the polls to do so. They did so in 9 days. So there's no question about complying with the timeline. They did so. And then the Constituted Authority have 2 weeks now to make their determination as to whether to send it to the election court or not. So there's no question about any timeline. That is a red herring argument. That does not arise. He acted within the time. That must be absolutely. In fact, if he had acted outside of the time, they would not have entertained his application.
Indeed.
So that is the first point. If he were outside of the 14 days, they would not even consider it. So the fact that it was brought before them, he was within time. That's clear. 9 days when he has 14 days max to put it before them. Because you remember, after the election, you know, he has to go and get his witnesses to compile the affidavits and make sure that everything is in order to send it to them. So the election can't be today and he send it to them tomorrow. It has to be together properly, and then he sends it to the Constituted Authority. And they now have to make a deliberation on it to see whether there are circumstances to warrant it going to the election court. And this is where they fell down miserably. Having supplied all that mountain of evidence within the time, their job was to now satisfy themselves that the evidence is there, and then immediately send it to the election court. They are not a court to determine whether or not they believe this or they don't believe this. Their job is to say, all right, he has put before us evidence. We are now, our job is to act as like a conduit now, send it to the election court. They are the ones who will test the veracity of the evidence. The witnesses can be called, cross-examined, and the court will now make a determination as to whether we should void the election. And they failed to do that. So having failed to do that, this is where we come in now. When it got brought to my attention, I see where they made an error. So we immediately, that's when I came into the case now, I immediately see that the procedure now is to go by way of judicial review and to ask the judicial review court to say, hey, Constituted Authority, you should have sent the man's thing to the election court because he has put before you sufficient circumstances for you to go to send it to the election court. And you see, what you must understand here is that let me give you a simple example as I did on the radio today, this evening. Suppose he had sent it to them and they say, you know, that fellow Buchanan, you know, I don't like that fellow Buchanan. He's a miserable fellow. He's a troublemaker. So he lost. I'm not going to send anything to the election court. Suppose they had said that. Based on what the judge did today, the judge said that you can't do anything.
Right.
The judge said that you should have gone to election petition. You see the absurdity in this thing, Bridget. This thing doesn't make sense. This thing defies all principles of law. The fact of the matter is that long ago, in a case known as Annisminic and Foreign Compensation Commission, the House of Lords made the point that all errors of law go to jurisdiction. So when the Constituted Authority failed to send the man's thing to the election court, that is an error of law. Because an error of law can arise when you fail to act on evidence or you take into consideration irrelevant things. It can arise in different ways. So in this case, they fail to consider relevant evidence. And what is the relevant evidence? Mounting. You have evidence of people invading polling stations, people double voting, open voting. You have people take command there in polling station, taking over the station. People couldn't come on within the 100 meter. People can't come and vote. Party songs and party paraphernalia being on display and to intimidate, influence. All of these things are recognized breaches under the Representation of the People Act, which was pronounced by the court in Blake and Holness as a basis to void election. So you have judicial pronouncement on these things already. They said these things will suffice to void an election. So if you have a court saying that these things will suffice to void election, how can an inferior body like the Constituted Authority refuse to act on that? You see the contradiction there? The Constituted Authority is known in law as an inferior body. They are not a court. They are a creature of statute. So they can act as if they were a court.
That's why you filed for cert.
Pardon me?
That's why you filed for certiorari.
That is correct, to quash their decision. The decision of an inferior tribunal. Exactly. That's the point.
Let me ask you. I'm reading the statute and I'm looking at how it was applied back in 1998.
Yes.
You talk about circumstances.
Yes.
They didn't talk about evidence. And
yes.
what I find troubling is that the Constituted Authority started looking at the circumstances and trying to deal with evidence out of it to say, we're going to look at the weight.
That's what I'm saying. That's what I said. That is their remit. That is not their remit. That is the remit of the election court. You see, their job, once a man put forward evidence, then their job is to say they have no discretion. Their job is to send it to the election court. And all the cases that have been cited, which have been accepted, even the case of Malaysia, the court makes that point, that it is the election court and election court only who has the discretion to determine whether the conduct complained of amount to conduct to void an election. So they can't usurp that function of the election court, which they have done. And so it was the duty of the judge in this case, as the supervisor of the court, to say to the Constituted Authority, hey, you overstep your bounds here. You should not have done that.
Right. Right.
And she failed to do that.
No, the judge made a big deal about an election petition.
Yes.
And when I went back and I look, I saw that Mr. Buchanan did not file an election petition.
That's correct. And there was no need for it. Once you go to the election, the Constituted Authority, you don't need. And that point was taken in the Blake and Holness case. You just read it. Make the distinction between an election petition and going under the Constituted Authority are two different regimes.
Right.
So why are you talking about election petition when the man comes under that regime, which the statute provides for? That is just to confuse.
No. She talks about the timelines, and she's saying time is of the essence with an election. And the judge even said there was no violation per se of the timeline in certain aspects, the way when things were filed, but it didn't file quickly enough. And I found that to be a start.
It is absurd. It is absurd. If the parliament says you have 14 days to file something and you file it in 9 days, can anybody say that you are guilty of delay? No, tell me. A little child going to basic school would know better than that. You have 14 days to file something and you file it in 9 days. Can anybody say that you are guilty of delay?
No.
So that is what is it? I don't understand this thing. So and let me explain something to you. By asking those questions, the judgment is inherently wrong.
Mm-hmm.
It is incurably bad. You can't be going on issues that are not issues in the case.
Yes.
The man did not file an election petition, so why are you talking about election petition? The man filed an application to void election under the Constituted Authority, which is section 44, set up under section 44 and 52 of the Election Petition Act.
Mm-hmm.
So why are you talking about election petition?
Let me just put this up again so people can see, because when I found this, if I found it, certainly the judge could have found it herself and she could have read it. Here it is right here. It says people, and this is in the Andrew Holness. Andrew Holness. It's the motion to, and it's the same type of thing that they brought.
That's correct.
They brought. I said the motion to void an election clearly is not an election.
An election petition. That's correct.
It's right there, folks.
That is simple. It's not.
It's right there. And
so okay, we're talking about the election petition.
And the court went on to say the voiding of an election is a new.
That is correct.
Different regime.
It's a new regime. It's a new regime set up.
Yes.
What are you talking about election petition?
I have no idea. When I saw that, I said, "Well, wait a minute. He didn't file an election petition."
And to make it worse, if you look at the judgment, the judge made the error again by saying that the Blake and Holness case was an election petition case. Not so.
It's right here. It's right here.
The Blake and Holness case was not an election petition case. It was a Constituted Authority referral case.
The judge said it right
so
here.
The fact that she can't even get that right, what do you make of that judgment?
It's terrible. No, assume that she's right, and she's just for the sake of this conversation, and she's right with the time bar. That is.
But she can't be right. We can't assume something that is palpable. There's no way to assume that they can't be right. It's wrong.
No, there's a question I want to ask you, but if we say that it was wrong, then we won't get to that question. I just want to pick your brain a bit. Talk to us now. She said, "Okay, there is a statute of limitations problem. You're time barred, and therefore you can't do anything." Talk to me about nullification and how that.
All right, let me explain that. The Constituted Authority is set up after an election is announced, okay? And its life run for 6 months after the election, okay? The life of the Constituted Authority is for 6 months. And what I think, as you see, you have to understand basic administrative law here. The fact that their life is for 6 months does not in any way make a determination of its decision being void statute barred. And then really for that, once something is pronounced to be a nullity, time does not run against that decision.
Thank you, sir.
That's basic administrative law. What nullity means is that it never had any life in the first instance. What you call in administrative law, it is void ab initio, meaning that it never started, never got out the block. So when the Constituted Authority made a decision by not referring the man's thing to the election court. That would have been a void decision, void ab initio. Therefore, time would not have run against it. All the time start to run when the Supreme Court, by way of judicial review, say your decision is wrong, so you must now refer the thing to the election court. That time start to run.
So the nullification would get rid of the time.
That is correct. That is correct.
Look, I'm stunned by this.
I believe me. My professor, Professor Fiaggio, who was a great administrative law professor at KVL, you'd have been astonished to see something like this. This is administrative law 101, basic. Would have been astonished to hear something like this.
You know, and when I read the opinion, I saw where the judge, with all due respect, the judge kind of got confused.
Yes,
writing was confused.
It is. It is so wrong, Virgin. It is so wrong. Let me tell you something, man. This could not even get a E grade at KVL, where I studied law. Could not even get an E grade.
Okay, so no,
because I had some great professors, and I consider myself to be a student in these things. And this could not even get an E grade at school, at university.
No, it is what it is. It's happened. Where do we go from here?
Well, look here. The only thing is to appeal it. Because this cannot stand. You cannot have something so palpably wrong to stand as the jurisprudence of this country. It is wrong. We have to, and you have to go to the Privy Council. Let go to the Privy Council. Let the white man determine it, because this can't make sense.
You know what, sir? I agree. I agree 100%, and I've been telling.
And I'm prepared to go to the white man with this, because it has to be dealt with. This cannot allow to stand as part of a jurisprudence. There's not one aspect of the judgment can be supported in law. Not one aspect of it.
Let's extend the conversation by looking at the question concerning a judgment that the election is null and void. What does that mean for what does that mean for the parliament? What does that mean for Jamaica?
And why this thing is so important, the stakes are very high. Once the court declares that the election in that constituency is void, then it means that we don't have at the time immediately. It means that the Prime Minister is no longer a member of Parliament, therefore there is no Prime Minister, therefore the Governor General would have to look to the Parliament and ask the governing party to appoint somebody else as the new Prime Minister, that he can have that person sworn in. So it has serious constitutional implication in the cabinet. Everybody would have to resign and reappointed.
This is very,
so this thing goes to the heart of the governance of the country. Because once it is voided, then he's no longer a member of Parliament, so he can't be Prime Minister. That means that you have to have a new Prime Minister sworn in by the Governor General.
What's the timeline you're looking at now for an appeal and oral argument submission?
Well, the first thing we have to do is, the rule is that this is an interlocutory appeal, therefore you have to get leave. So what we have to do, by tomorrow we'll be preparing the application. We have to go back to the Supreme Court for leave, because we did not ask today, because we did not know the basis on which the judge did what she did. So we could not have asked for leave at that today, because you have to know on what basis you're seeking leave to appeal. So now that we have looked at the judgment and see what it is all about, I now know what it is that we need to go to the Supreme Court to ask for leave to appeal on. So by tomorrow we'll be preparing that application for leave to appeal, file it to the Supreme Court, and try to get a very early date, because this matter goes to the question of the running of the country. So it has to be dealt with quickly. So we are hoping to get to the Court of Appeal as quickly as we can with this matter. It has to be dealt with quickly. You can't have something like this lingering.
Two questions. One is, what's the possibility of the judge who issued the judgment today getting a chance to determine your request for an appeal?
Well, we are hoping that that person will not. But even if she does and she refuses to leave, it doesn't bar us from going to the Court of Appeal. It can't stop us because it's just a procedural thing that you have to ask. And even if she refuses, we still have the right to go to the Court of Appeal to get it.
Okay. The next question.
They can't stop it. But it will be easier if we get the leave, so just file the appeal immediately.
Next question. Is there an expedited process in the justice system the justice system, the judicial system in Jamaica, where because of the nature of
that's what I'm saying. I think that this has to qualify as one of those instances. And we think that we'll be filing an application of urgency, affidavit of urgency in this matter, that it has to do with the constitution of the parliament. And so we're asking that it be heard as a matter of dispatch.
Well, look, I don't want to keep you any longer because I know you had a long day and you're probably going to have a long night, because I'm sure people will be calling you and
yeah, because the people are obviously upset over what took place. It is a clear case. It's a clear case. It's one of the clearest cases I have seen of judicial review. Up to now, the judge has not said that the evidence placed before the Constituted authority is not compelling evidence to void the election. And she has not said so either.
Right. She
has not said so. All she said is that the timeline and petition, she has not said that the evidence doesn't qualify to go to the court, to void the election, Because how could she? Because remember, what was put before the court was so compelling. You have a situation where the law says that after the close of the poll, the returning officer must put in place an arrangement for the transporting of the ballot boxes to the counting center. And that arrangement must include the agent of the candidate. That was breached in an egregious way in this case. The man's agents were not there. The ballot boxes were commanded by some unknown police officers. And that is when the system went down and everybody was watching the thing.
Right.
And it detour from the agreed route. In one case which was accepted by our court in the Blake and Holness case, the identical thing occurred. A case of Malaysia, where the route was diverted from by the returning of the presiding officer, saying that he was going to drop off his sister-in-law and stop at her home and deviate from the route to the counting center. And the court in Malaysia said that was a serious breach and void the election on that basis. In the Blake and Holness case, Justice Walker said that breach was such a serious breach that amount to evidence to void the election. And all the breaches that were pointed out in the affidavit were qualified for that sort of treatment as was done in the Blake and Holness case. So if the election court in a decided case said that these are serious breaches of void election, how can an inferior body like the Constituted authority say otherwise? You see the point I'm making?
That's the point you're making.
How could an inferior body override the Supreme Court, the election court, which comprised 3 judges?
And something that I was thinking about, that, well, wait a minute, if the election court will stand until March of next year, I don't see where the timeline would be.
No, but it doesn't matter. It doesn't matter, because let me explain something to you. Once the court pronounced what the Constituted authority did is a nullity, then whenever it is done, the election court would have to be convened to hear the matter because of the concept of nullity. So time has nothing to do with it here. So let us say take a year for them to make that determination because the court system is slow. Then the election court will have to be convened to hear it. Time doesn't run against authority.
I don't know this judge. I suspect that you do. I don't know how well you know her. But what do you think would cause a judge to
I said I prefer not to go there. We'll leave it at that right now.
All right. Is there any parting word? Do you have any parting word for us, sir?
Well, this ruling today defies logic, it defies law, it defies common sense. And I believe, well, I've been getting a lot of calls, people who have started reading it, lawyers, and they are amazed when they hear what happened and see what happened. They can't believe this because these are basic principles of law. You see, administrative law, public law generally, is an area of law which there are not many people who understand it, And every day I'm seeing it more and more coming out. And this is an example of that. These are principles of law that I used to enjoy as a student in Barbados, with my professor, And they would smile and laugh at this when they see this. So what is this, Wildman? Not making sense. It's not making sense. Oh, I mean, how can a court say that something being a nullity, time would make it statute barred? Can you believe that? Let me explain something to you. In the case of Bernard Cord and others who were convicted in Grenada, everybody remember that case, the Morris Bishop killing and others. And the men were convicted in Grenada, some 17 of them, including Phyllis Cord. And they were commuted, the death sentence were commuted to life by the Governor General acting on the advice of the Mercy Committee down there. And years ago, this is not happening in the 80s, And years ago when I was in Grenada, how many years it have passed? The men brought a constitutional motion right up to the Privy Council to challenge the death sentence that was imposed on the men on the basis that the sentence was a nullity because it was a breach of the Constitution, that the men were not given the right to mitigate fair hearing doctrine before they were sentenced. And they succeeded because of the concept of nullity. Years after the men were sentenced, convicted and sentenced. That's how the concept of nullity operates. So it doesn't matter how long after, if you discover that something is in breach of a statute that affects somebody's right, especially due process, time does not run against you. Time doesn't run against you. That is basic law. So how can you say that because the life of the Constituted Authority is for 6 months, or the election code life is just what? It doesn't affect the time, because once a court hears a case and say, yes, these breaches render the election void, be null and void, then what would happen is that what the court is there saying is that the election that was conducted in West Central was not in keeping with the law. It's void. So it has to be rerun. And the body that makes that pronouncement would have done so after hearing the evidence of the nullity.
Is this the type of case that could come before the CCJ?
We're not under the CCJ, we're under the Privy Council, so Jamaica would not be able to do that. If we were under the CCJ, we could go straight to the CCJ after the Court of Appeal, but Jamaica is not under the CCJ, Jamaica is under the Privy Council.
Okay, the reason I ask is because I know that the CCJ, they deal a lot with commercial type matters.
Yeah, but this is a commercial matter. This has to do with the election law of Jamaica.
I know, but I said that to the person, but the person said to me, is there any prohibition against them listening to this matter as opposed
No, they would have no jurisdiction because we're not yet a part of the CCJ regime. We have to go to the Privy Council.
Well, look, Mr. Wildman, we want to thank you for your time and thank you for your effort and thank you for being a stalwart in the fight against election malpractice. So we wish you all the best. We wish Mr. Buchanan all the best. And from where we stand, we're looking at this very, very seriously because we believe that a wrong was done here, and we thankfully procedure to right the wrong. And
yes, serious wrong was done here.
Some people they don't like when I say, look, I respect the judge's opinion, but I don't agree with it. You know, you have respect to it. And people say, no, you can't respect it, or you have to respect. But that's the way lawyers speak. That you say, look, I respect it, but I don't agree with it. And there are procedures to deal with that decisions that you disagree with. You don't have to beat up the judge or anything like that. But this one here is a stunner.
Yes, it is.
We'll be watching, and I'm sure tomorrow we'll get a readout of the because you said you're filing the appeal tomorrow, right? Or
well, at least we're going to start the preparation of the document for tomorrow. I don't know if we'll file it tomorrow, but at least tomorrow we'll be preparing the documents for filing.
All right. Well, look, Mr. Wildman, thank you so much for your time, sir, and we look forward to seeing you real soon. And I'll talk to you. I'll call you tomorrow. I have something. There's something that I need to talk to you about.
Okay.
You and I know what it is about. So
yes. Okay.
Yeah. For yourself. All right. We'll talk, sir. Take care of yourself. Be well.
Yeah. Okay.
All right. Bye bye. People, you see exactly what I'm talking about, right? There it is. You heard it from Mr. Wildman. He's a man who brought this case to the Supreme Court. And it's very clear when you read the opinion, when you read the 1998 opinion, you have a clear understanding that what the judge did today was not in keeping with the law. Because as we said, she's looking at this as an election petition, and it's abundantly clear that what Mr. Wildman filed on behalf of Mr. Buchanan, or better yet, what Mr. Wildman was arguing was that it's not an election petition. And the court back in 1990, the same action, because if you recall what happened in December of 1997, there was an election in the same constituency between Mr. Blake, I think his name is Warren Blake, and then I think it was his first time running in representational politics, Andrew Holness. The election was in December of 1997. They came back with the results saying that Andrew Holness won. Mr. Blake decided to challenge the results, and he went through the Constituted authority, and then they filed the action on his behalf with the election court. The court listened to the matter, and the court said, issues, too many problems, null and void, do it over. They did it over, I think it was in March or April of 1998, and Mr. Blake won. Mr. Andrew Holness challenged that victory. Same process he went through. He went through the Constituted authority, and he went through the election court. And the court said, problems, do it over again. And I think it was in June of 1998. They had the third election, and Mr. Holness won, and there was no challenge. But I need to show you something, because Mr. Holness if certain things had happened, we probably would never heard of Mr. Holness. And I'll show you what I'm talking about. If certain things had happened, we probably would have never heard from Mr. Holness. This is the case, the same case that we talked about earlier. This case that was heard March 5th, May 28th, 1998. Let me show you something. See this? Take a look at that. Mr. Andrew Holness of the JLP was declared duly elected as the Member of Parliament for the constituency, defeating the PNP's Warren Blake by 153 votes. This is the first one. This is the first election. Keep that in mind. 153 votes he won by. Keep that in mind. Now look at this. I'll show you something. Let me skip all of this. Skip this, skip this. We're getting there. Okay. Is this it? Okay. $49. All right. 150 something he won by, right? What was it? 157 something, 154, 153. All right. He won by 153. All right. In the same election, they looked at polling division 49, right? I'm going to get you the number. I'm going to go down and get you the number I'm going to go down and get you the number for this. All right, here's one. Here's one. Polling division 64. The same one that he won by 150, same election he won by 153. Look at this. They said that at the final count in polling division 64, in the same election, they said 128 ballots were found to be disfigured. And before that, though, when they did the preliminary counting, they had 186 votes for Warren Blake, 6 for Andrew Holness, and 0 for the third candidate. Something is wrong here. When they did the initial count, they had no problems. And when they did the final count, they said, wait a minute, 128 of the ballots were found to be disfigured. People, you don't need to be a scientist. You don't need to be Einstein to figure out what happened here, right? You know what I mean? 166 and 6, 186 versus 6. That means he beat him by 180 votes. He beat him in this polling division by 180 votes from the preliminary count. Remember now, Andrew Holness won the election by 153. Warren Blake beat him in the polling division by 180. Look, I'll show you another one. Show you another one. Look at this one here. Look at this one. Polling division 72. And here's a mistake that they made with this. Here's a big mistake they made with this. You know, you have the preliminary counting, and then you have the final counting, and they don't happen the same. I think that they don't happen the same day. In this case, they happen 4 days apart in polling division. What happened when they did the preliminary counting? President Carter and his wife were there. The ballots were counted, and here's what the ballot showed: that Warren Blake in this polling division 72 received 338 votes. Andrew Holness received 7.
He beat him by 331. Remember now, Andrew Holness won this election by 153. So he lost in one polling station. He lost by what, 180, something like that. And now he lost by 331. That's 511 votes. In 2 polling stations, 511 votes lost to Warren Blake. And Andrew Holness won that election by 153. People, come on. Here's a mistake they made, though. The Carter Center came. It was the first time, maybe the only time, they came to Jamaica to exert oversight over the election process. CAFE, C-A-F-F-E, I believe. It's a local organization, and they exert oversight as well over the election process. What happened here was that, especially with the Carter Center, they did the preliminary count. And in this case, 338 against 7. The final count occurred, I believe, 4 days later. Guess what happened in the 4 day span? The Carter Center was gone. Because if they were there, they would have said, wait a minute, hold on. It's 338 when you did the preliminary count. So how come now there is 0 in the box? It's right here, if you disbelieve me. There it is. On the 22nd of December, during the final count, this box was found to be empty. 346 votes disappeared. 346 votes disappeared. Remember, the Prime Minister, well, it wasn't the Prime Minister, but candidate Holness won by 153. And yet, there were 511 votes that went to Warren Blake. And in this case, 346 votes, ballots, disappeared. Just disappeared. My people, you cannot make this up. And see, I'm sitting here giving you facts. This is not my interpretation. This is the court's interpretation. This is the election court in Jamaica. And even Andrew Holness and his lawyers, they even made a mistake. I'll show you the mistake they made when they brought this action. I'll show you the mistake. Remember, we said, okay, what do? You file when you want to complain about an election. You file with the Constituted authority, produce your affidavits. They look at the 4 corners to make sure that at least one of the 5 elements, one of the 5 is there, and then they move it on to the election court. If you go through the Supreme Court, one of the things you have to do, remember I said you have to file a security deposit. You have to do a security deposit. Guess what? Here's what Andrew Holness said. Let me show you what Andrew Holness said. There it is. Here it is. It says Andrew Holness, the declared winner on the 27th day of February, filed a notice of motion to dismiss the application of the Constituted authority. The grounds to dismiss are, and here are the grounds, that Andrew Holness was on the 17th day of February, the member elected as having received the majority of votes, which is a joke, that the Section 40 of the Election Petition Act has not been complied with because you have to pay. Remember what I said? You have to pay that security. Here it is right here. He said that security for the payments, that it's mandatory. And he said it has not been given. There it is. And then he started saying the constituted authority, you know, it had people on it that shouldn't be on it. That's his argument. Because he's saying that it's an election petition that Warren Blake is filing to contest the election results. Look at this. Look what the court said. Again, we've read it like 2 or 3 times already. See there? The judge says, I find the submission untenable. The motion to void an election clearly is not an election petition, so you don't have to put up any security deposit. All of those things that you have to do for an election petition, they're saying no. Why? The voiding of an election is a new and different regime created by the recent amendment to the Representation of the People Act 1997. It's different. Completely different. Because when you contest it now, you go through the constituted authority to the election court. Before that, you would go to the Supreme Court, and then you wait. One of the things I should have asked Mr. Wildman, I didn't ask him. I should have asked him why. Well, he wouldn't. I don't think he would have been able to answer the question. Why didn't the parliamentarians, the lawmakers, why didn't they void the Election Petitions Act, or at least that part of it that says you have to go to the Supreme Court? And when they passed the amendment to the Representation of People Act, saying that now you can go through the constituted authority to the election court. Why didn't they nullify it? Why didn't they just say, we're finished with this law, this is how we're doing it? Because they said, the reason why we're putting in this new process is because it's faster, it's more efficient. You don't have to wait years to get a decision. You hear what I said? Once the court hears it, it's 6 months before the new election and everything is over and done with. 6 months. So this is clearly a problem, my people. Clearly a problem. I won't even, I'm looking at the judge's opinion right now, and it's like, it doesn't make sense to go through it with it, because you've heard a summary of what was said, or of what she wrote. And that's it. She spent a lot of time talking about election petition, and an election petition was never filed. And then she started talking about statute of limitations and deadlines, and those are not the issues. The issue, to be clear, the issue was whether or not the constituted authority had the authority to review the affidavit for admissibility of evidence, quality of evidence, weight of evidence. No. All they needed to do, all they should have done, because here's what it mentions. It doesn't even mention evidence. It says circumstances. That's what the law says, circumstances. So all you have to do is, within the 4 corners of that document, that affidavit, is to say, here are the circumstances. On such and such a date, I was in the polling station, I was threatened by a gunman and others, and so I left. It is not the job of the constituted authority to ask you, well, did you see the person? Can you identify the person? What kind of gun was it? When did it occur? Where were you positioned? It's not their job to do that. That's the job of the election court, my people. That's the job of the election court. So what happened is the constituted authority took on those responsibilities, acted like a court, started questioning the circumstances concerning evidence. It's not their job. That's not their job. So, what time is it now? 10:09. We can go till 10:30. What I'll do is I'll open up the phone line, a special broadcast, and I want to hear from you. What do you think about this matter? Somebody said, Greg Howell said, Ratty come with a whole heap postulating, which is not normally grounded if facts not reality. Greg, I tell you what you do. Look, check out the document here. Let me show you something. I don't know how good you are at reading, but I want you to take a look at this document. I want you to take a look at this document. I want you to take a look at this document. Take a look at this document. This one here. The election court document 98. I want to take a look at this because this is very instructive as to how you look at the statutes. I don't know if you're a lawyer. I doubt that you are one. But if you are one, you're a very poor lawyer. I wouldn't give you a case to argue. But if you're not, read this because this is a good primer on the difference and the similarities between the Representation of the People Act and the Election Petitions Act. Read that and then we can have a conversation. Otherwise, I don't think it's worthwhile for me to spend any time with you. Okay, yeah, we got rid of another idiot. We're wasting his time, so we put him out of his misery. The phone line is open, folks. So here it is, 667-369-8569. 667-369-8569. And around here, right, my people, I know, one of the things that I take pride in, and you have complimented me on, is that I don't come here and just chat. I show you the documents and then tell you go read it. Caller, good night. Welcome to special edition of Reason with Rattigan. How you doing?
Hi, Mr. Rattigan. How are you doing?
I'm fine, thank you.
It's my first time calling.
Okay, welcome. Thank you.
With watching you, but I have some concern, deep concern. I know you guys are fighting for Jamaica, and you are fighting for the Jamaican people. I am one of them. But at the end of the day, I am still asking, is our fighting going in vain?
Okay, that's a question. That's a question?
Yes. Is our fighting going in vain?
All right. Any other question before I answer you? Because I really want, that's a very important question you ask.
And the next question is, today, with Mr. Buchanan and the election, I was sitting down, before today, I was sitting down and I did not expect any other result away from the one that we got today.
Right.
Because first and foremost, every case and your own is lost. He lost, and I know Mr. Buchanan would never have win because Andrew only sold us out as Jamaican. I am a Jamaican, a proud Jamaican, love Jamaica. That's the most beautiful country on earth.
Yeah.
That's Jamaica. That's my country. I love my country. I don't care what nobody is saying.
Mm-hmm.
With the result I got today, I'm very disappointed. That's number 2. Number 3 question. When are we as Jamaican, strong Jamaican who really love our country, Jamaican, the beautiful island that God loves so much, used to be a praying island, an island that God loves. And what I always enjoy is when I go to work and I ask, and they ask me, where you from? I'm from Jamaica. They light up.
Mm-hmm.
I'm from Jamaica, and they went there and they love Jamaica. We as Jamaican, with myself included, do we see any change, any time, any soon is going to come for a change? Because we need a change. But we as Jamaicans, it doesn't matter where we are from. America, all right, Jamaica is everywhere you turn in Jamaica, in the world. There, if it's even one Jamaica, we are there.
Mm-hmm.
Because Jamaica is so nice. Everybody loves Jamaica.
Mm-hmm.
Everybody loves Jamaica, our country. Is there, this is a third question, is there any hope for us? Because I am worried. I am very worried as a Jamaican. And now Trump is telling us we're supposed to decide between our citizenship and Jamaica. Me choose America. And I am not proud to say it so, but I choose America because I went back down there to live and it wasn't like that. And I came back here 2012. From 2001, I went to Jamaica and lived. It was the Honorable, what's his name? The Prime Minister was there, down there in 2001. The Honorable,
PJ? PJ.
2001, what's his name again?
They're talking about PJ Patterson?
The PNP Prime Minister.
PJ.
And I went to that gentleman. And then I left down there. When I left down there, it was Bruce Golden, and then it was Mama P.
Right.
And I came back here to live. But it doesn't get any better on my view. It got worse.
All right.
Because I remember I was down there when they was doing the killing in Tivoli Garden, which was Bruce, what's his name? Bruce Golden?
Yeah.
Yes, Bruce Golden. And then we came back and I saw he left it over and gave it to this man right here. Because I don't have a name for this man. Every time I see this man, I'm upset. And to be honest, we share the same last name, and I am upset. I am so upset that I don't even know where we are going. We are Jamaica going now. That I see that you are fighting as a FBI. We live here together. I live in Maryland. We live here together, and I see that we have to fight for Jamaica because that's the country that we love. That's the country that is so good to us. Everybody loves Jamaica. Jamaica is a special dot on the map. We are a dot. But everybody loves Jamaica. Where are we going from here?
All right.
Where are we going from here? Because I've seen so much things. I am so upset. Right now, I am here and I'm living and I'm here. I can't find most of my family.
All right. I tell you what. Let me hang up now, hang up from you, and then answer your questions.
Yes.
All right. Take care now. Be well.
Yes, I love you. Thank you.
All right. Now, the caller asked some serious questions, and they all relate. I think they're connected. Some of them are the same questions, but asked in a different way. She asked about Well, first let me address one thing she said. She said that the current president of the United States is saying that we have to choose a nationality, a citizenship. So they want to end dual citizenship. Just to correct you, caller, that didn't come from the White House. It came from a member in the House of Representatives, and it's a bill. It's not law, and I doubt that the way it's written right now, it will be law, because a lot of them will not give up their Italian citizenship. They won't give up their Polish citizenship. They won't give up their Irish citizenship. They won't give up their UK. A lot of them, they're from Europe, or from Central and South America. They're not going to give it up. So the way it's written right now, I don't see it passing into law. I can see a version of it. I can see where they can tweak the language a bit, but that's a story for another day. Let's get to the questions you asked. You said, are we fighting in vain? You said you were disappointed with the result, today's result. You said, look, we need change, but when are we going to get the change? You ask, is there any hope for us? And then you ask, where are we going? Let me just say this, and I firmly believe this. You know when you've lost? When you fail to get up. I love these challenges. I thrive on these challenges. Because when these things happen, the intellectual and the other juices in my body, they just start to flow. And I start thinking, okay, how can I get around this? Because at the end of the day, we cannot yield, we cannot surrender. We cannot. It's not an option. The resolve should be stronger now to say, look, we have to do something now. And I tell you what, caller, you say you live in Maryland, and here's the thing that I'm hearing from people overseas. They're saying, you know, we're doing all of this talking and coming up with things and doing this, and we don't see where the people in Jamaica, the ones who are suffering the most, we don't see them helping their cause. We don't see it. We don't see them voting. We don't see them protesting. We don't see them doing things that would inspire other Jamaicans. Because people have said to me, I thought by now we would have a massive protest in Jamaica because of Melissa and other things. And we haven't seen it. We haven't seen it. So fighting in vain? No. If you believe in Jamaica, call, and I know you do, I can hear it in your voice, and you said it. When you spoke, I felt it. So how can we give up? How can we say and I know you asked a question. You didn't say that we're fighting, and you asked a question. So I'm just responding. I'm not saying that you said it's a waste of time. But you asked the question, are we fighting in vain? I said, no. Think about all the people, our ancestors, who fought and died so that we could have the right to do the things we're doing today. Think about people like Paul Bogle, William Gordon, Nani, Kodjo, Marcus Mosiah, Bob. And then if you live here, then you think about people like Martin Luther King, Malcolm X, and all the civil rights people. If they had said, and believe me, they fought a lot of fights, and they lost a lot of them, but they didn't stop. Let me take this call. I'll come back to your caller. Caller, welcome. Good night. Welcome to the special edition of Reason with Rattigan. Where are you calling from?
I'm calling from New Mexico, Sir Rattigan. How are you?
I'm doing well. And you?
I'm doing fine.
Talk to me. What's on your mind?
But are you really surprised about the ruling?
All right. this is a follow-up to what the first caller said, right? And you heard the first caller.
Yeah, I'm listening to the program.
If you remember, if you watch this program, if you remember, what did I say? I said I need people to put aside $100. You remember I said that? Put aside $100.
I heard you.
Yeah, and I said, why? Because we have to fund the appeal. And I said, this is not for a political party. This is not for a political candidate. This is for the principle of good governance, the sanctity of the relationship.
We need to start from the top.
I'm sorry, what was that?
Bottom up. We have to start from way up there.
Yeah. Well, you heard it. You heard why this decision is so important. It's so important to us to get it right. Because if the election is declared null and void, we don't have a prime minister. Because in order to become a prime minister in Jamaica, you must be a member of parliament. And so if it's null and void, he's not a member of parliament because now they have to run the election. And so the ruling party would then have to submit a name to the governor general and said, here is the person that we think we have confidence in to lead us and the government. And then the cabinet would have to resign because now under the constitution, the new prime minister, any new prime minister has the right to select his or her cabinet. So they would have to resign. And if if that person wanted all of these people who are ministers now to remain in the cabinet, he could say, no, I'll keep it as it is. But you realize the impact of this decision, that we don't have a prime minister. And that's why the prime minister is worried, because this is immediate. This is not like filing something with the state.
Who say he's worried? Do you think he's worried?
I think he's worried. And you know why I think he's worried? He may not be worried about this decision today. He may not be worried about that, but he's worried. You hear what Mr. Wildman said, that he's willing to take this all the way to the Privy Council.
And that's where it ought to go. And he must not only say it, but that it must go there. Because you know what? I think also this judge, I don't know. I just think she knows better, but she's just giving him time. She's buying time. She does it deliberately because she knows. I listen to Stacey and I listen to Mr. Wildman talking to you. And that's a clear cut. I'm not lying, but that is so clear cut.
Yeah.
And President was already with his case when he won the election with the same election thing, fraud that he said there was. And the truth is that Andrew Holness has now become a demigod. He is. And don't tell me I'm wrong. He is. You know what his problem is? He has it all cut and dry, because he's looking at a part that he's taking this country. And many of us don't see what Andrew Holness sees. And know that they are so rude and disrespectful in Parliament. Like when you have a set of unruly kids that you need to just be correct.
Yes.
And need to browbeat like Juliet Holness does in Parliament. They out and go. They are very disrespectful and they are not good for Jamaica. They need to go because I don't know when Jamaica politics get to where it is now. Andrew is a dictator. Right. And he feels that he cannot be stopped and he must be stopped. If it's the Privy Council, let it go and we are here to support.
Okay.
He needs to go.
All right. I like your thought process. And that's why I've been telling people, when you said, did I expect any different result than the one we got today? And I said, listen, put up your $100 because what we're doing is we're going to support this principle. And if it means we have to go to the Privy Council with it, then so be it. And people are saying, well, the Prime Minister is not worried. I don't think he was necessarily worried about this decision today, but he's going to be worried going forward.
I think he knew how it was going to go today.
Yeah, but he's going to be worried going forward
it would not go any further.
Because
and
you can
just must go further.
Right, you can just think about the headlines when it gets to England, and then now it comes on in that the Prime Minister, he's fighting this thing, even though there are reasons for the election to be declared null and void, and the judges in Jamaica didn't. And remember now, what was it? Vibes Cartel, I think, went to England to get justice, right? And some people might say, well, Some might say, well, he wasn't adjudged not guilty. It's just that the procedures, they didn't follow the procedures in Jamaica, right?
Yeah.
They didn't follow the procedures with the tainted jury. And here it is, they didn't follow the procedures with the constituted authority. So sometimes you lose not because of the substance, but because of the procedure. And that is where we are. So.
Well, I think Paul Buchanan just need to sharpen his axe and keep going. Just keep going, because there has to be a light at the end of the tunnel.
Okay.
All
right.
Know what I look at? I'm not taking the discussion in another direction.
That's all right.
But I'm looking at even the hurricane relief, how Mr. Holness is actually approaching this thing. And it is partisan. When people suffer, they don't suffer because they are green or orange. They suffer because they are people and because it is a natural disaster. And everybody suffers. And look at how this is being handled. That man needs to go.
All right.
Yeah, no empathy. He needs to move, and as quickly as possible he needs to go. He stole the election. The election was bought. And he didn't even humble himself when he gets there. And now them face the out of order. He's very disrespectful. When I look at how they talk to Mark Golding in Parliament.
No worry, man.
I know he shuts up everybody else and using his sarcasm to see if he can. Because Andrew knows what he's doing.
Well,
he's a rude fellow. His wife is better.
Here's what I want to thank you for the call, and I'm going to invite you to continue to support the program. Put aside your $100 and tune in this Saturday, because we're going to, two things you mentioned we're going to deal with. We're going to deal with the unruly behavior in Parliament, and we're going to talk about the relief effort. We're going to do a segment on the Office of Disaster Preparedness and Emergency Management and show you the history and show you where it is. So tune in for that. I have to run now because I have to go take another call. All right?
Yeah, blessings. Take care of yourself.
Likewise. Take care now. Bye-bye.
Okay.
Caller, good night. Welcome to Come Reason with Rattigan. Special edition of Reason with Rattigan. Where are you calling from? Hello?
Good evening, Sir Ratty.
Yes. Hey, Wagwan, man. Talk to me.
Hey, man, we could see this decision coming from last year.
That's why I'm going to put up the $100. That's what I'm going to You see it a mile out, right?
Yeah, we see that. Well, last time I talked to you, I was saying, might as well we get ready for the Privy Council, because they're not going to get a fair shake in that system. People think otherwise, but I don't believe it.
But you know what's, Bim, you know the thing about it that's crazy is that the judge got it wrong. It's not even close. I mean, if you look at the law, the two laws, Representation of the People Act and the Election Petitions Act, and you look at the decision made in 1998, and you look at the petition that was filed in 2015, you realize that this judge is way off base. Way off base, because the first mistake she made, and once she made that mistake, it was fatal. You can't come back from that when she said that it was an election petition the man filed. And the man didn't file an election petition. He didn't.
Yeah.
And so everything she said after that was just wrong. Then she started talking about deadlines and statute of limitations, and you heard, those things didn't factor. What should have mattered was whether or not they have the authority to determine the weight, the admissibility, the quality of the evidence, or should it have been referred to the election court.
You got to look on the last few decisions I hear, most of them judges on them. Like I was looking at the case where you file this case against the Prime Minister, and that decision, and I look at this decision now, and a few more decisions, one with SW Buchanan, with that kind of stuff, and I wonder where these people getting their law degree. I wonder if it's the same place that the Prime Minister get him from up the Doctorate of Delaware, because
it's just amazing that the judge could have gotten it so wrong. There's so many ways she could have handled this. There are about 3 or 4 ways I can think of that she could have handled it, and this is the worst way she could have handled it, because I believe that she's going to be overturned. the decision is going to be overturned.
Yeah, it's gonna overturn, but I keep wondering, is this incompetence or is something else?
Well,
Because
you're not trying to get
Mr. This case is just straightforward. I was listening to
it's a straight
wild man, and
yeah,
I was reading along with everything what it was showing there, and unless incompetent, you should be able to spot that a mile coming if it's a judge.
yeah, it's a straightforward. It's a straightforward case. All the mumbo jumbo she went through, it was unnecessary, uncalled for, and it just didn't make any sense. And all I'm asking people to do is just go look at the decision. But before you read the decision back in 1998, and then read the Representation of the People Act and read the Election Petition Act. Because once you've read that, you will be fully versed. You will be eminently qualified to look at this issue and determine whether or not this judge did the right thing.
Yeah, I was following on the Blake decision in what, 97?
98.
Yeah, and once it just a carbon copy, and this one is just a carbon copy of that one.
Yeah, it's a carbon copy because he didn't file an election petition back then, and the judge says when you challenge the election, it's not an election petition, so you don't have to go through the Supreme Court, right? Because that's where you go with that. And the judge made several references to the statutes to say this is not an election petition. This is a petition to the constituted authority for passage onto the court, the election court. And what the judge had to do, the law mentions circumstances, not evidence. Circumstances. It says as long as you can make out the circumstances, then you're fine. The constituted authority has no authority to go behind and beyond the four corners of the document. And that's exactly what they did. That's exactly what they did.
Yeah. Yeah, that's crazy. Another thing, all these people, who appoint these people to be, or you become a judge, or you become a judge in Jamaica, who appoints them?
I think there's a judicial body. What's it called? It's called the Judicial Services Commission, and I think it's a constitutionally created body, and then they're responsible for the appointment of judges. But of course, people get referred. And so you know it goes.
Definitely, because if you're gonna review them and scrutinize them, a lot of these one would make the cut.
Right.
So it's frustrating and disappointing, but man, it shouldn't be that blatant,
Right. I see bright little stars in the chat says, how much will this appeal cost? And all I can tell you is that whatever it costs, it's going to be worth it for us to support it. It's going to be worth it.
Yeah, that we'll get behind it and do what we have to do.
All right, my brother. So let me go grab another call here. So we'll talk soon.
Breaking up.
All right. We'll talk soon. All right. Caller, good night. Welcome to the special edition of Reason with Rattigan. Where are you calling from?
Good night, Mr. Rattigan.
Hey, Miss Philly. How you doing?
I'm good.
Talk to me.
Mr. Rattigan, listening, and when you ask Mr. Wildman, what next? Where do we go from here? And to hear him say, we're going to challenge it, oh my God, it gives me joy. Trust me. Because I would not want them to just leave it like that.
Right.
So we're going to move on. We got to send a message to those judges that sit in chamber and do the foolishness, you see, and think that they are privileged. Yes, they might be, but a but is there. Mm-hmm. They must do better. Mm-hmm. So that will send a message. And now Andrew Holness highlighted, and now Friday the most still, and the higher the monkey climb, and the more my exposed, because We went to the privy council before, and we're going to go back again. That is to show that the injustice in Jamaica and the type of ruling that they're doing. And I'm finished with that. I'm so elated.
All right.
Good night, Mr. Rattigan.
Take care of yourself. Thanks for the call. Yeah, people, you know, like we said, they're just 5 things on the section 37 of the Election Petitions Act. There's just 5 areas that you can complain about. And once you make out that complaint, for example, one of them is, and I'll put it up again for those of you just joining us. Let me put this up. Here we go. All right. Look at B. That ballot boxes have been stolen or destroyed. Right? And remember back in 1997, that's 1997, 1998, that was one of the complaints. 2 ballot boxes. When they open them, 0. Even though the Prime Minister combined, he lost by 511 votes in those 2 ballot boxes, but he won the election by 153 votes. Didn't make any sense. Caller, good night. Welcome to special edition of Reason with Rattigan. Hold on 1 second. Let me just finish this point. So, okay. So, folks, what I'm saying is that all you have to do, they said you just have to make out the circumstances, not provide evidence. The law doesn't require you to provide evidence to the constituted authority. You provide evidence to the election court. All it says is that you just provide in your affidavit the circumstances concerning your complaint. So for this one, you would say ballot boxes were in the place. They were supposed to be transported, and then when we got to the counting station, they weren't there. You've made it out. You don't need to say, well, you know, it was this guy, and then they went this way, and then that, and it's not their purview to ask you questions like who, when, where, why, what, how. They look at the document. The only thing you have to provide to the constituted authority is affidavits. That's the only thing you have to provide to them. And so they have to look at the 4 corners of the document and say, okay, have you made out one of these 5 provisions? Have you made out one of them? Have you? People who are, look at D, people voting who are not bona fide electors. You just say, hey, this person voted, and then when we look that the person wasn't on the list. You don't have to go now and say, well, when did this happen? Because you can put that anyway, the date, but you don't have to say, well, the person lived down here and did this and that. No, they're asking you to conduct investigations. As long as you make it out in the 4 corners of the document, then it has to go to, if you didn't make, like for example, if you put inside of your affidavit to them that I didn't vote because the other party, the road was blocked. They might look and say, well, it doesn't fall under anything. Some people might say, well, that falls under DE, but it certainly is not A, B, C, D. And I can think of all kinds of situations that you could complain of that the constituted authority could say, looking at the document and looking at the requirements, you haven't made out a case. But when you did it in the case of Mr. Paul Buchanan, and I've read the submissions where you say people voted more than once, they were still they violated the 100-meter rule. They were still campaigning. They were intimidating people outside and inside the facility. They didn't have their agreed route. They deviated from their agreed route, and then we didn't see them for several minutes. And then they drove through the stronghold of the prime. All of these things, they've made them out. So that's where we're. Caller, sorry. Thank you so much for holding. Welcome. Talk to me.
Yes, good evening, Mr. Rattigan.
Yes, sir. Good evening.
Yeah, thanks for putting on the show. So, you know, a lot of us can get a hold of what really happened. You know, I saw highlights and things like that, but I wasn't able to read the document. But I'm just going based on what the first caller said. I have a few things I want to say, but I just want to remind the people that, look, freedom is not given, it's fought for. And we can't get weary because the freedom that we are fighting for, a lot of us is not going to live to see it. Them of us saying that the guy who invented the wheel never drive a Mercedes, right? Paul Bogle and Sam Sharp and Nanny and a lot of these people never get to live to see the freedom that they were fighting for. So we have to just keep fighting, and we don't want to dampen nobody's spirit, but we may never even get rid of Andrew Holness. He may serve out his time and walk away off his own free will. But what we're fighting for is to shape the laws that surrounds him, and also as Mr. Wyman also said, the jurisprudence. If we protect that and help to shape that and help to educate the people, right? That is what's going to shape our future, I believe. So sometimes the tangible things that we want to see to happen is just not going to happen.
Right.
Right? So I don't know what say you about that, but my question to you, do you believe that this judge, somebody pull this judge in a corner and have a chat with this judge and even the constituted authority for them to make so much that decision and try to, because to me, this is like a cover up. They already made up their mind, but they're trying to find legal ways of covering up, which it turns out to be a blunder.
All right.
Right. And they may even say what we say, what you said, right? You know, if this goes through, then the country's in a conundrum. We don't have a prime minister, we don't have a cabinet and all this stuff. And the questions may be put to these people: do you want to be the one? Do you want to be that guy? Do you want to be the one that made those decisions? But as we always say, Jamaican like a lot of us Jamaican like when white people tell good things. So we should just let the white people tell us what's right and what's wrong.
Okay. All right. Well, hang up and let me answer the question you raised.
Yeah, man.
All right. Thank you so much for the call. The caller mentioned something that reminded me of something I learned in law school decades ago. And it's this. One of my professors, can't remember who it was, but he said, sometimes a court will look at the facts and apply the law and render a decision. Sometimes the court would have already concluded based on biases, because we all come to the table with biases. But they've decided in their mind, this is how this thing should go, and then they come up with justification for it. So one of them, it's going forward, and one of them is like going backwards. One of them is saying, hey, you know what? Let me look at the facts, let me apply the law, let me render a decision, and that's it. That's my conclusion. Another one is saying, this is the way I feel about this. Let me come up with something now to justify it. It could very well be the case with this, because you know why I say that? Because the reasoning doesn't make sense. The reasoning doesn't make sense. She's arguing that the man filed an election petition and the man didn't file an election petition. How could she miss that? And then she's saying that the constituted authority was charged with a responsibility by Parliament to exercise discretion. They have discretion of reviewing this thing and talking about evidence. No, that's not the case. That is simply not the case. So, caller, you're right. Sometimes it's done that way, where they said, okay, this is how we think this thing, this is our belief, this is how we think this thing should go, and then they search around enough to justify. Because remember now, when a judge issues an opinion, it's not a yes or no. You know, you issue the opinion, but then you have to justify how you reach that opinion. And that is where the problem is, because if it was simply a yes or no answer with no justification, she would probably get away with it. But because she has to justify it now to put it on paper, we can look and say, well, wait a minute, this doesn't make any sense. Her justification doesn't support her decision. It's not in harmony, because her justification involves certain assumptions that are incorrect. So therefore, certain assumptions that are substantially incorrect, and therefore her decision, her opinion is also going to be incorrect. So, you know, that's where we are. So it's, again, some people just say that's how they do it, and they put the justification after they have, you know, because the way it's supposed to go, you do the justification and then you reach your opinion. But some people reach the opinion, they have the opinion, and then they say, okay, no, let's find something that we can, you know, let's find reasons that we can provide to support the decision. It's supposed to be the other way around. You have the reasons, and then the reasons will support the decision. Not you have the decision, and then you're going to find reasons to support it. So her interpretation is just way off. So I'm asking all of you this Saturday, tune in, because we're going to, hopefully by then we'll have the GoFundMe. And I can tell you that I have not been approached by Mr. Buchanan, neither Mr. Buchanan nor Mr. Wildman. None of them have asked me to set up anything. I'm just saying that we're doing this as a people because we believe that the decision, Rose McIntosh said it's questionable. It's even more than questionable. Hello, good night. Welcome to special edition of Reason with Rattigan. Where are you calling from? Hello? Oh. All right. We have 10 minutes, people. Caller, good night. Hello? 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 Caller, good night. Welcome to a special edition of Reason with Rattigan. Where are you calling from?
Good night. Good night.
Yes, sir.
Well, the judgment, if the judge makes such a decision as you're saying it there, that means that he will be above the law and the judge is not ruling on law.
No, the judge, my opinion, and it's only my opinion, and keep in mind, people, I'm not a practicing attorney in Jamaica. I'm just using my legal education to assess what took place. And I took the time to read the law. And not only did I read the law, I read the law quoted and used by the judge. She used the Election Petitions Act. She used the Representation of People Act, and she used the case involving Blake versus Holness in 1998. She used all of those things, and that's what I did. I went and I looked at all of those things, and I also looked at the submissions filed by Mr. Wildman. So I have a pretty good idea of what happened, and I encourage people with a different opinion to say, okay, fine, let's talk about it then. If you have a different opinion, tell me why your opinion is different.
But then, so why would be the language that she came up with today? Then, if that is the case, then why would you use such a language?
Why would what? Why would she use? I don't understand the point.
Well, okay, you know, when I just became decision, in give reason for the decision. Why would the decision, if you think about, okay, this is not A and B, it's wrong, why would you make me say it is late?
Yeah, but it can't be late, because what happened, she looked at it from a different angle, and the angle she looked at, it had nothing to do with this case, because she started out by saying that it is an election petition, and it's not an election petition. It is a filing. It's a filing.
Did the judge make a wrong ruling?
I beg your pardon?
You are saying the judge made a wrong ruling?
Oh, you think this is the first time it's happened?
No. I know that's why you have the upper court, because the lower court always make a wrong ruling.
Exactly. Yeah, I believe it was a wrong ruling.
You are saying
yes.
No?
Yes. I'm sorry, I didn't understand what you were saying. But yeah, I understand what you're saying. No, yes, she made a wrong ruling. And we're allowed to say that. And we're allowed to put up the reasons why we think she made a wrong ruling. And I think we have. To the greatest extent, I think we have showed that. I mean, Mr. Wildman was on the program. I don't know if you watched the segment with him or while he was on, but he made the argument. And the argument legally, logically, and otherwise, spot on. Made sense.
So then you don't think Mr. Wildman would have gone to challenge it on that basis why the ruling that it made is wrong.
That's what he's doing. I remember he said,
and I'm apologizing because I just came in and I was hurrying as hell to get to get to you this evening, but things coming out of the way. So
no man, no worries. No. Well, tune in on Saturday because we're going to take out that clip. We're going to play it on Saturday so you can actually hear.
No man, we have to go replay you, man. What do you? We have to go replay you.
All right, brother. Thanks.
We have to go replay you.
Thank you.
Can't wait till Saturday.
You can't wait.
No, we have to go replay. I just done something. We put in.
All right.
From beginning.
Much appreciated.
We try everything we get you, but one of them things.
Much appreciated. All right. Well, look. Go back and listen to it and then tune in Saturday because we have some more things we have to talk about on Saturday.
Yeah, man, me the panic every time.
All right, my brother.
Build a house for you, man.
All right. I won't let you down, I promise you.
Yeah.
All right, take care now.
Yes, a good night.
All right, bye. Yes, people, we have 5 minutes to go. Let me just, caller, good night. Welcome to the special edition of Reason with Rattigan. Where are you calling from? Hello? Hello? Hello?
You hear me?
No, can you have speak up louder, please?
Can you hear me?
Yes, I can hear you, but you're low right now.
Greetings and salutations, everybody.
Yes. Can you speak up?
Wait. Can you hear me now?
A little bit better, but you're still low.
What could I watch? All right. Greetings, everybody. Just to remind everybody of one thing, that everything that is happening from this point on, especially coming from this platform, is a matter of principle, not politics.
It's a matter of what? A matter of what?
More people understand it's a matter of principle.
I can't hear you.
Yeah, you hear me any better now?
Yeah, you're still low. I can hardly hear you, and the voice kind of muffled a bit.
No, you can't hear me.
Oh, principle, not politics. Okay.
Yes, son.
Okay.
Oh, because I'm gonna get my voice yet.
Okay. No, producer Otia helped me out because I guess she can hear you. So she just wrote to me and stated what you just mentioned. So it's a matter of principle, not politics. Okay.
Yeah, it's a matter of, I just remind everybody because the regular listeners would probably understand that it's not politically motivated, but just as a matter to remind everybody else and to let those who don't know. When you look at what is happening in Jamaica right now, a lot of it on the basis of principle,
right?
A stand needs to be taken.
Okay.
Because it's affecting people on both sides.
Okay.
Some people might not say it affect them, but they might feel the pinch nonetheless because they support the ruling party.
Right.
But the pinch is being felt.
Yeah. Point well taken. Principle over politics. Anyway, me have to go run now. Me have to go run. Me have to grab one more call before we leave. But thanks for calling and continue the support. Here, sir?
Yeah, man.
All right. Take care. Bless up. Caller, good night. Welcome to...
Mr. Rattigan, quickly, let me say this to you as I hang up because I called not too long. Mr. Rattigan, what if the judge herself was afraid to make that ruling because remember, and she made send the documents off to the where it's supposed to go, the voting court, whatever. And then remember, Parliament would have to dissolve and all of that and so on and choose someone to run the country. I believe the thought just come to me that perhaps she would not want to be the one to make that obsession. Right? So therefore, because under Holness have every organization and system in Jamaica under suppression. So that thought came to me because to me, a lot of people is afraid to do what is supposed to be done, the right thing, the correct thing. So that thought came to me that she might be afraid for her life. So perhaps she did it that way. Okay. Then I go to appeal court, and then from appeal court to privy council. Make them go on with that, but I don't want to be the one to be judged to say, well, I'm the one who do all of this ruling.
All right.
Now, to send the documents forward.
All right.
That's what I thought about.
All right. Hang on. All right. Thanks. All right, folks. It's 11 o'clock now. There's one person trying to call. I'll keep the phone line open for another minute. But Miss Philly is making the point that this judge could be fearful for her life, and she just said, look, I don't want to be the person who's going to cause this catastrophe, this political catastrophe in Jamaica concerning governance by ruling that the election is null and void, because then once that's done, then there's no prime minister, there's no cabinet. Well, Miss Philly, she didn't have to do that. We'll just turn off this phone here. All right. She didn't have to do that. Here's what she could have done. And here's what Mr. Wildman was asking her. One of the things he was asking her to do, she could have simply sent it back to the Constituted Authority and said, listen, your job is to examine the four corners of the document, and then you make a decision and send it off to the election court. But it's not to determine the evidence. You're only supposed to look at the circumstances. That's what the law says. Circumstances. It doesn't mention anything about evidence. And that's what they did. They started looking at the evidence. And therein lies the problem. Therein lies the problem. They're supposed to look at the circumstances, not evidence. So that in and of itself is a serious, serious, serious problem. I'm just looking through the all right, here's what happened. They did use the word evidence, but they used it in terms of the affidavit. They said, you shall make such request and shall furnish the Constituted Authority with such evidence on which he, the complainant, relies, which, and here it is, what's the evidence? Affidavit. So it's a piece of paper swearing that everything you're saying here is truthful. And then they look at the 5 provisions. It's not their job to go and start questioning. That's why we have a court. Because then the court is going to say, okay, bring in all the witnesses, all of these people who file these affidavits, bring them in, if you have video, if you have audio, if you have other types of evidence, documentary, bring them in. And so now we're going to hash this thing out. and determine if the election should be declared null and void. And by the way, don't forget that in the Blake versus Holness case, some of the same arguments made in that case in 1998, they're made in this case in 2025. And the arguments that were made in 1998 were successful. They were successful. So the question is, if they were successful then and the law didn't change, then why aren't they successful now? And the reason is because the judge says, oh, it's an election petition. And then she also said the constituted authority had or has discretion to determine, they have the right to look at these things and determine if it should go. Yes, but how do they look at it? You're only supposed to look at the four corners of the document. You're not supposed to go beyond that. That is the purview. That is the bailiwick. That is the preserve of the election court. That's it. OT, hit me. People, listen. It's a pleasure. Don't start it at OT. Pleasure hanging out here with you guys, going over this very important topic. And we look forward to seeing you on Wednesday. By the way, tomorrow night, I'll be on Mystic Sensation. You can tune in for that. I'm sure he's going to discuss this as well. And then on Wednesday, we'll see you on Come Reason with Rattigan. And then on Saturday, you know, all the things set up already, we'll do that. And I just want to thank Chief Corey and Ambassador Anu for coming on this past Saturday. And we're going to cut that clip and send it out because as you heard them say that a lot of things you see on social media, not true. And also they've reached out requesting assistance to help their community, and feel free to go ahead and make the donation. On Saturday, I think we're going to put everything up so that you'll be able to access all the platforms that you need to access, or the payment structure to get whatever you need to get to them. So I just want to thank them again for coming on this past Saturday. What is this? OT, urgent donations. We need your help to get donations and packages to those affected. Please donate to help others. More for OJLDF. Yeah, we have there is a container. I think one left already. One is leaving two, I believe, are leaving next week. One left already, two are leaving next week. We'll provide more updates to you concerning that. So just want to thank you again from the bottom of my heart, my people. Oh, here's another one. Hearts for Jamaica Relief Fest. This is going to be one of the biggest shows, if not the biggest show of the year. Well, apart from like the Rotterdam reggae festivals or whatever, but certainly the biggest one in America. It's going to be held Sunday, December the 14th from 10 a.m. to 10 p.m. Riviera Beach, Florida. A tremendous amount of talented musicians will be there. You name the name, they will be there. There is a flyer right there, people. Check it out. Check it out. Check it out. Sunday, December 14th from 10 a.m. to 10 p.m. Riviera Beach in Florida. Anything else, OT, before we go? Oh, Jesus is Lord, say. Okay. Excellent teaching, sir. I thank you, Paula E. All right. OT, let me go. Let me go. The people want to see people up here. All right, people. Thanks again. See you tomorrow night. Mystic Sensations. Wednesday night. Home with this
Defending your rights, I saw him stay. Say from him step up all eyes on him. I defend the people, them set spice on him. Even politicians spread lies on him. But we know the bugger them not wise like him.
On October 28th, Melissa, a Category 5 hurricane, turned her wrath upon our homeland, Jamaica. In the aftermath, thousands of homes were destroyed, lives, pets, and livestock were lost, and dreams and hopes dashed. Resilient as we Jamaicans are known to be, our brothers and sisters on the island need our help now. To this end, the One Jamaica Legal Defense Foundation, OJLDF, has launched its official fundraiser. Please donate generously at OJLDF.net. We are depending on each and every one of you to get the most needed supplies to our people at home. Go to OJLDF.net. That's OJLDF.net and hit the donate button today. Thank you.